I said that. I also said, in fact, I said, who's the expert who said the time? Judge Ray, can you tell me a little bit about Ruth Bader Ginsburg and how you met her?
Yes, I had the privilege of meeting Justice Ginsburg when she was a member of the Court of Appeals for the District of Columbia. And at that time I was a federal judge on active duty, and specifically I was the Chief Judge of the United States Court of International Trade. And I would often be assigned to sit on the various courts of appeals by the Chief Justice of the United States, and I had the privilege of sitting with Justice Ginsburg on the United States Court of Appeals for the District of Columbia Circuit. And that's how I met Justice Ginsburg.
You mentioned that she won a few cases as an attorney before the Supreme Court.
Oh yes, she has a very distinguished biography. She was a professor of law at Rutgers University School of Law and at the Columbia Law School, and she earned renown in the 1970s for her teachings and litigation aimed at ending institutionalized discrimination against women. In 1971, she was instrumental in launching the Women's Rights Project of the American Civil Liberties Union and served as the ACLU's General Counsel from 1973 to 1980. And she served also on its National Board of Directors from 74 to 1980. And between 1973 and 1980, she won 5 out of 6 cases she argued on women's rights before the Supreme Court. And she was appointed a judge of the United States Court of Appeals for the District of Columbia in 1980 and assumed her seat on the United States Supreme Court on August 10th, 1993. But as I say, I met her and had the privilege of sitting with her on the Court of Appeals for the District of Columbia Circuit, when I too was an active federal judge, and I was then the Chief Judge of the United States Court of International Trade.
You were the Chief Judge for how many years?
Well, I served on the court as Chief Judge from 1977 until I retired in 1991.
That's an amazing tenure.
Well, see, I was appointed by President Johnson in 1968 and served as a judge, as a federal judge, from 1968 until 1991. But I was Chief Judge of the court from 1977 to 1991, and I was designated Chief Judge of the court by President Carter.
I was surprised to hear you had an interest in opera, and I know that Ruth Bader Ginsburg, Justice Ginsburg, also has an interest in opera.
Well, I surely have an interest in opera. As a matter of fact, I take great pride in the fact that when I went to high school, and I'm a graduate of New Utrecht High School in Brooklyn, where I received an excellent education, and I'm very grateful for the wonderful education that I received in that public high school. I was with the orchestra there and was in the violin section, and it was a marvelous experience because then through my various friends I learned the drums as well, and throughout my college career played with some very fine dance bands and played all sorts of functions.
While you were a judge, you were still teaching at
Part-time,
St.
only
part-time.
But when I was full-time from 1947 until 1961, when I was appointed the chairman of the Foreign Claims Commission by President Kennedy. But our distinguished guest today is Justice Ruth Bader Ginsburg. I'm only the person who had the privilege and pleasure of inviting her to come, and I was so pleased that she said yes, and she will be with us any moment. Welcome to St. John's. We're so happy that you are able to be with us, and we're grateful to you And I want to thank you at the very outset for your kindness and goodness in being with us.
Ed, I'm delighted to be here, and you know there's one big reason why I'm here, and that's you, the Honorable Ed Ray.
Well, you're very gracious. I do recall some of our sittings, and I recall particular sittings in Washington on the Court of Appeals for the District of Columbia Circuit.
Hello, Justice.
Justice Ginsburg, Dean Bellicosa, dear friend.
I know.
Dear friend.
Ed and Peggy.
Hi, John. How are you?
Wonderful to see
Please
you.
be seated. Please be seated, Justice Ginsburg. Please be seated. Please.
I'm glad to be here.
Yes, I can see the smile. That's great. That's wonderful.
Joe.
Yes.
And I'm glad, even though we're in Queens, that there's a representative for Brooklyn television.
That's what you call fortuitous planning.
Yes,
Irvin, by the way, is a dear friend. Irvin Eisensteinus has been
Nice to
at
see you.
various places where I've had occasion to speak, and he's been so good that nothing ever leaves until I first see it.
Mm-hmm.
And our relationship is marvelous.
Well, I can tell, as most of yours are.
You know, we have.
You want us to talk a little more about what Ed and I have in common?
Oh, that would be.
My favorite borough.
Our favorite borough.
Also born in Bed-Stuy,
That's right.
around the corner from where St. John's was founded in 1870, Lewis and Willoughby.
That's where the college was. 75 Lewis Avenue.
Mm-hmm.
Well, I spent my growing up years at 1584 East 9th Street, between Avenue O and Avenue P,
Just where that is.
and went to PS 238, and then James Madison High School. And you were
PS
you were-
176
but you
and New
were
York High School.
in New Utrecht. You told me, a first violinist. I was a last cellist. I had the experience of being in an orchestra, and the violin, there was much too much competition with the violin. I played the piano. So I chose the cello. For one thing, when you learn the cello, it doesn't sound like a drowned cat the way learning the violin does. And for another, that it wasn't such a popular instrument. So throughout my high school years, I was in the last row of cellos, which was good enough for me. I always made the first note of every bar, sometimes not much more. But the experience of being in an orchestra was wonderful.
Oh, I went back there.
You told the story of the New Utrecht Auditorium. My memory like that was not of either school, but of the Brooklyn Academy of Music. And some years ago, I went to the LIU graduation ceremony, and the tears came down my eyes because that Brooklyn Academy of Music was my dream place. It's where I saw they had, my mother had a subscription to the children's shows on Saturday matinees. And the first time I ever saw Henry V, the film, was at the Brooklyn Academy. And to me, it was the grandest place I had ever known in high school, and it's still wonderful.
Mm-hmm.
That's where we held our graduation ceremonies.
When we were in Brooklyn, yes.
And I had the great privilege, when you mentioned Brooklyn Academy of Music, I had the privilege of being the commencement speaker both for St. John's and New York Law School, because it had closed down during World War II. And I spoke for both the schools, and there used to be a program, the American Forum of the Air at the time. And I'll never forget the dean asking me to see him to inform me that we were going to be on the radio. And he said, now, do you need any help with your commencement speech? Of course, he didn't know that I started writing it when I got into law school. And it was really wonderful because there I had both schools, and later on when I taught at New York Law School for a long time when I was on the court, the dean still remembered the fact that I had been their commencement speaker, and the St. John's program indicates that there was this joint program.
Oyez, 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 but you have come to such wonderful attention immediately that
I can dispense with that and say welcome to everyone. Justice Ginsburg, Judge and Professor Ray, and the Ray family, Reverend clergy, students and faculty, alumni, distinguished guests of so many people, overflow crowd in all of the other rooms and in the corridors. It manifests the excitement and the enthusiasm of this wonderful day for St. John's University School of Law. And as dean of this magnificent law school, I relish the high privilege of opening these proceedings and welcoming everyone with a simple and a brief message. Because time is so precious, we are extremely grateful that Justice Ginsburg has found the time in her extraordinarily difficult and busy schedule to grant the gift of her time and of her energy and of her insights to the community of St. John's University School of Law. I sincerely thank the esteemed Justice and look forward to her presentation and her conversation with all of us. We are so delighted that this extraordinary jurist, teacher, scholar, and preeminent champion of women's rights for decades should appear here in this magnificent Belson courtroom at our law school. I might say that what Jackie Robinson did for baseball in Brooklyn, or perhaps I can suggest Justice Ginsburg has done for the advocacy and the advancement of women's rights. We're very, very proud, of course, of her historic accomplishments and breakthroughs. And she shares that Brooklyn heritage that I mentioned with so many people in this room, Judge Ray, and we were just talking about it, and myself, and I suppose, in a sense, most importantly for the institutional perspective, with St. John's, which began very humbly in Brooklyn. So we're especially delighted that it is so appropriate and fitting that that connection, too, exists for us. With my personally imposed time limitation on myself, a virtual red light blinking on the oral argument lectern, perhaps, that I recall myself, and I know Justice Ginsburg so well aware, I have the additional honor this afternoon of recognizing our own distinguished professor of law, the Honorable Edward D. Ray, and so many of his family here, including, of course, Peggy. This lecture series bears his illustrious name, and Justice Ginsburg has very specially honored St. John's and Judge Ray by accepting his personal invitation to be here with us today. For that, and for so much more, we are very deeply grateful to Judge Ray. And without further ado, I am now pleased to invite our very wonderful and respected colleague, Professor Ed Ray, to the lectern for the singular distinction of presenting our revered and respected guest lecturer, the Honorable Ruth Bader Ginsburg. Judge Ray.
I think this is wonderful. I just got a bright idea. I think I'm going to ask the dean to introduce me to my classes. I'd like to treat it this way. This is marvelous. I'm sure that it would improve the lecture. Well, first of all, I want to tell you what this is not. This is not the Judge Ray Memorial Lecture. There's something to say coming in here. So the news of that fact is, as has been said before by, I think, Mark Twain, the news of my death has been greatly exaggerated. It is my great privilege and honor to present Justice Ruth Bader Ginsburg, Associate Justice of the United States Supreme Court, who will be the 2002 Distinguished Lecturer here at St. John's Law School. It is with great pride that I state that Justice Ginsburg was a professor of law at Rutgers University School of Law, Columbia Law School from '72 to 1980, and Justice Ginsburg has earned renown in the 1970s for her teachings and litigation aimed at ending institutionalized discrimination against women. In 1971, she was instrumental in launching the Women's Rights Projects of the American Civil Liberties Union, served as an ACLU General Counsel from 1973 to 1980, and its National Board of Directors from 1974 to 1980. She was appointed a judge of the United States Court of Appeals for the District of Columbia in 1980, and assumed her seat on the United States Supreme Court on August 10th of 1995. 93, I beg your pardon. That's good, so that none of us get the impression that we're infallible. And so, it is with the greatest pleasure that I present the 2002 Edward D. Ray Distinguished Lecturer at the St. John's School of Law, Associate Justice Ruth Bader Ginsburg.
When the Honorable Edward Ray asked me to visit St. John's, I could hardly refuse. Among his many accomplishments, he was one of the first people I knew, one of the first lawyers who was deeply interested in international and foreign law. Today, those fields are blossoming in law schools all over the country, but it was not that way in the early 60s. And also, he's very dear to my heart because he was a good friend of the judge for whom I clerked, Judge Edwin L. Palmieri. In fact, I know you will understand this, Ed. You two, he was your landsman, is that right? So I'm happy to be here, and I'm going to tell you a little bit about the way the Supreme Court works. And then I hope what I say will prompt questions from you when I'm done. How does the Supreme Court go about doing the job that the U.S. Constitution assigns to it? First, what is that job? It is, in the main, to settle as the final arbiter questions that arise under federal law, the Constitution itself, but much more often, the ordinary laws that Congress enacts in great abundance and heavy density. The court is not what lawyers call an error correction tribunal. And by that I mean we don't take cases simply to correct wrong judgments. That job is handled by the appellate forums, state and federal. What we do is to try to keep the law of the United States more or less uniform. That is, when other judges divide on a question of what federal law is, then the Supreme Court will intervene so that we have the law of the United States and not the laws of the United States on the same subject. I'm going to talk to you first about how the court goes about deciding what it will decide, how it chooses cases to review, and then about oral argument at the court, and finally, how we reach our decisions and write our opinions. We start each term with a giant conference the Monday before the first Monday in October. This term, that conference is exactly 5 days from today. It will be held on September 30th. At that conference, we dispose of all the petitions for review that have accumulated in the summer months, petitions filed from June through September. That opening conference and all our conferences are closed, absolutely confidential. No person other than the 9 justices can enter the room when we confer, no secretary, no law clerk, not even a message carrier. For this first conference on Monday, we will have a list of over 2,000 cases, petitions for review and other applications. Once the term gets underway, we will have between 100 and 300 cases listed for each conference. In all, nowadays, we receive somewhere between 7,000 and 8,000 requests for review annually. In the term just finished, precise number was 7,889. Well, how do we manage those large numbers? Typically, we put less than 15% of the cases on the list for discussion. I will describe in just a few moments how we winnow the list down to the relatively small number that we actually discuss. But first, let me mention the voting choices we have. Most often, we will vote simply to grant, or much more often, deny the petition. And it takes 4 votes to grant a petition. But we have other options. Sometimes we put a case on hold, carry it over, we defer it, while we are considering another case, a related case, granted review, or we may relist a case for a future conference. Any justice can ask to have a case relisted because he or she wants more time to consider the proper vote, or occasionally to write a dissenting opinion from the court's vote to deny review. And it happens more than occasionally that those dissenting opinions never see the light of day. In fact, it is the definition of success if they don't get published, because it means that one or more justices were persuaded to add the vote that was necessary to get the count up to 4 to grant the petition. So those unpublished dissents and denials of cert will be closed to the world until the justice is long gone and the papers donated to the Library of Congress or some other institution are open. Sometimes we will vacate a lower court decision and send it back for further consideration in light of a decision that we recently released. And sometimes we will invite the views of the Solicitor General before we vote on a petition. The Solicitor General, I think most of you know, is the Department of Justice officer who represents the United States before the Supreme Court. And when we call for the solicitor's views in a case, the solicitor is acting as a true friend of the court. He will give us his honest count on the importance or unimportance of the question to the sound development of federal law. It is a bit of an exaggeration, I think, to call the Solicitor General the 10th Justice, as some writers have. But he does occupy a very important place in the Supreme Court's adjudication. 1 or 2 times a year, we may find a case important enough to decide, but the answer so clear that we can dispose of it summarily without briefs beyond the petition and without oral argument. Let me give you one example. A colleague and I had that heady experience as lawyers in the mid-1970s. We gained a summary reversal when we petitioned the court to review a Utah Supreme Court decision. Utah, in those now ancient days, flatly denied unemployment compensation to pregnant women. Our client supported by the ACLU, our clients, were working women. They were laid off from their employment and unable to find other jobs. They were also pregnant. The Utah Supreme Court said that the state's law barring unemployment compensation to pregnant women, that law was clearly constitutional because once a woman became pregnant, she could not be considered ready, willing, and able to work. The Supreme Court, U.S. Supreme Court, found no need for a full breast presentation in that case. It held Utah's denial of unemployment compensation to pregnant workers clearly unconstitutional. The judgment, therefore, was reversed unanimously and summarily. When you win a case that way, without a brief, without oral argument, it is a little like for those who are golfers getting a hole-in-one on the front nine. Getting back to how we manage the large numbers of review petitions, a few days before every conference, and that was 2 days ago for this opening conference, the chief circulates a list of all the petitions that he thinks worthy of discussion, and then any other justice in the next day or two may add other cases to discussion list. So we've been very busy in my chambers checking the chief's list to see if there are any cases not on his list that I think we should discuss. If no justice asks to discuss a case, it will be denied automatically, and that is the fate of about 85% of the petitions for review. We spend a lot of time in that process. Some people outside the court think, well, the justices read the law clerk's memoranda and they vote the way the clerks tell them to. Well, it doesn't work exactly that way. The clerks are invaluable. Every petition, no matter how lowly, will be read and summarized by a clerk. All of us to do that job, all save Justice Stevens, who goes over his own petitions in his own chambers, but 8 of us combine our clerks, and for the purpose of reviewing petitions, they are clerks not to any particular justice, but to the court. And they summarize the petitions. Then I have standards of the ones that I would like to see. And if any of us, if we're left uncertain after reading the law clerk's memorandum, we would always go back to the original pleadings, whatever else is necessary for us to make a sound judgment. My law clerks tell me that they spend about 1/3 of their time on the review petitions, as distinguished from the argued cases. Probably a little more in the beginning of the year when they're unfamiliar with it, and a little less perhaps as they become skilled in digesting the opinions below and the briefs. As I said before, and our law clerks are invaluable, but the justices sit all alone and discuss cases all alone, so it is not true that clerks decide the cases, although I know the feeling of a young person. I've had the experience in the D.C. circuit of standing outside the elevator while the law clerks were discussing their various opinions. And so I tell my clerks every year, watch what happens in the conference. Your colleagues will tell you, oh, my justice is going to vote this way, but it ain't necessarily so. Since 1988, the Supreme Court has had almost total control over the cases it will take up for review. 1988 was the year when Congress eliminated almost all of the must-decide cases. That is, until 1988, the court's docket was set in some 20% of the cases. They were cases where review was mandatory and the court had no choice. Congress, with the enthusiastic approval of every justice, made our review almost totally discretionary. So the cases that we're nowadays obligated to hear are few and far between. They're mainly certain Voting Rights Act cases, dominantly cases involving redrawn electoral districts. And then there are the original jurisdiction cases in which the court serves as the court of first and last instance. In the main, those are cases between two states, or between a state and the United States, generally about land ownership or water use. An example familiar to some people here from a few years ago was the contest between New Jersey and New York over the ownership of the landfill portions of Ellis Island, the island that was once the admission station for immigrants from Europe to the new land. New Jersey prevailed in that fray, and as a sign of how impartial we are, the one justice born in New Jersey, Justice Scalia, voted for New York. He was on the dissent side, and the one justice born in Brooklyn voted for New Jersey, was in the majority. Well, when Congress eliminated the large must-decide category in 1988, the number of cases that the court accepted for review began to shrink from about 140 per term to now between 70 and 100. Last term, for a typical example, we granted review in 88 cases. Some of them were consolidated, so the court issued opinions in 75 cases. With fewer cases and more time, the hope is that one can write better, or at least more comprehensible and hopefully shorter opinions. And I can assure the students here that it does take time to write it short. More time, most significantly, helps us achieve less dissension among the justices. So with the shrinkage in the number of cases we actually hear and decide, our unanimity rate has gone up. It's now, at least as to the final judgment, 40%. We are unanimous in about 45% of the cases on the bottom line judgment. And that's a point that the press rarely picks up, because I suppose controversy makes more interesting news than agreement. But to give you a concrete example, 2 terms ago, we produced 81 decisions, 34 were unanimous in the ultimate judgment, 26 in the opinion as well as the judgment, in contrast to 24 where we divided 5 to 4. And that 24 was high that year because one of the cases was Bush v. Gore. So last time we divided this most immediate term, but we divided 5 to 4 in only 24% of the cases, as opposed to 29 the preceding year. Well, as I said in the beginning, and as our rules tell lawyers, the press, and the public, we take cases primarily to keep the law of the United States fairly uniform, to resolve what the clerks call deep splits not likely to heal without the court's intervention, splits among federal and state tribunals. About 70% of the cases that we take up for review fall in that category, with courts all over the country deeply divided on what the federal law is. Now and then, when I pick up the paper to see what the reports are on our courts doing, I will see a headline like, Court affirmed decision X, or Court upheld decision Y. And the case is one that didn't even appear on our discussion list. What we did was we denied review. And a denial of review, I cannot overemphasize, says nothing at all about what the court would do if it in fact took up the case for review. There are multiple reasons why we might not take a particular case. It may be what we call a bad vehicle, the facts are not good. Or it may be one where the lawyering is dreadful and we're waiting for one with more competent counsel. And we generally await a deep split, I think, not so much to keep our caseload down, but because we are aided and we are enlightened by the variety of opinions that the good judges all over the country will give us. If we have a range of opinions on the hard issue, we will be better equipped to make the ultimate decision. Because we know that the nine of us possess no greater wisdom than federal judges and state appellate judges. Judges are, of course, fallible, as all mortals are, but they try to get it right, and appellate judges in the United States generally do. When I said that luck plays a large part in the particular nine who were there at any one time, some of the greatest judges, at least of my day, were not appointed to the Supreme Court because the wrong party was in power or some other reason. I can mention from this area, from the Second Circuit Court of Appeals judges, Henry Friendly and Learned Hand were never on the U.S. Supreme Court. Outstanding judge from the Ninth Circuit, Shirley Hofstepper, would have been Carter's appointment to the court if he had one. Alvin Rubin and John Minor Wisdom from the Fifth Circuit, Roger Traynor from the California Supreme Court, extraordinarily able jurists, but were not seated on the Supreme Court. So what Justice Robert Jackson said about the court, I think, is exactly right. He said, we are not final because we are infallible, but we are infallible only because we are final. We must be the last word. Incidentally, Justice Jackson is perhaps best known because he was the lead prosecutor at Nuremberg, but he was also the justice for whom the current Chief Justice Rehnquist served. Let me turn now from how we decide what cases we will take up for review to the day in court. I told you that we labor long in selecting cases, but unlike courts of appeals, where litigants arrive as of right, we spend no energy deciding which cases will be listed for oral argument. Many courts of appeals, facing huge backlogs, decide most cases nowadays without any oral argument. The Supreme Court, except in the rare case that summarily affirmed, gives oral argument in every case, and every case gets exactly half hour per side. Our chief is a scrupulous timekeeper. When the argument time is running out, there is a 5-minute warning light, a white light, and 5 minutes later the red light goes on. When the red light goes on, that's the end of the argument, whether it's a justice or the lawyer who's speaking. The chief says, case submitted, call the next case. I'd like to read to you what one of the best observers of our court's proceedings said about what oral argument is like. And he is Anthony Lewis. He's now a columnist. He was, for some years, the New York Times Supreme Court reporter. He said, oral argument does not play the part in the work of the Supreme Court that it did in the 19th century, when Daniel Webster and other bar luminaries would argue a case for days on end. The modern Supreme Court limits argument severely to a half hour per side, but argument still has an important function. It is the one chance the justices have to grapple directly with the lawyers who represent the clashing interests before them. It is also a rare opportunity for the public to gain insights into the minds of those who actually make the decisions. More than any other officials in Washington, the justices still do their own work, assisted only by a handful of young clerks. To observe them as they question counsel in the courtroom is to see an extraordinarily open process, unaffected, human. In a capital puffed up with bureaucracy and public relations, the court seems old-fashioned, small, personal. I can tell you that if you visit the court, you will see no laptops on the bench, but each of us has a quill pen and an inkwell. For the lawyers, oral argument is a direct opportunity to reach the nine minds with an idea, a phrase, a fact. Not many cases are won at oral argument, but a case can be lost if a lawyer is unable or unwilling to answer a justice's question honestly and persuasively. I agree in full with Anthony Lewis's observation about the court. In the most essential way, argument at the court is what you would find on appellate courts, both federal and state, throughout the country. It is not an occasion for speeches. It is an occasion for an exchange of ideas about the case, a dialogue, a conversation between knowledgeable counsel and judges who have done their homework, a hot bench, as appellate advocates say, judges who have read first and foremost the decision we are reviewing, and I want to emphasize that to all of the lawyers and future lawyers in the room. The first thing that any of us read is not a lawyer's brief, but the opinion that we are reviewing, because there is a certain tendency of lawyers to slant or slightly distort what the opinion below was. So we get it straight from the author of the opinion below, and then we turn to the briefs. The briefs, that's a misnomer, because the briefs are, well, lawyers tend to fill the space allotted, so we allow 50 pages for opening brief. It's rare that we will get one with only 40. And then, so there's two sides have 50 pages, then 20 pages for the reply brief, 30 pages for our many friends, the amici, who file in support of one party or the other. Some lawyers, I'm told, don't like the way we conduct oral argument. They would much prefer to present a planned lecture. And there are some justices who ask few questions. Justice Harry Blackmun, who retired from the court in 1994 and died in 1999, often recounted the advice that he was given by Hugo Black in 1970. Harry, Justice Black's caution, never ask many questions from the bench, because if you don't ask many questions, you won't ask many foolish ones. But it seems to me a loss of a precious opportunity if an advocate can do no more with her oral argument than recapitulate the briefing. She will serve her client and her cause better if she is agile, if she welcomes and responds to questions that may uncover what is in the justice's minds, while remaining alert to opportunities to use a question as a springboard to advance a key point. So I don't follow Justice Black's advice, and in that I am hardly alone. 3 members of the current court, Justice Scalia, Justice Breyer, and me, were once full-time law teachers, and that breed is addicted to asking, what if, or suppose that. Questions from the bench give counsel a chance to satisfy the court on matters that the questioner at least thinks significant. and might resolve less satisfactorily without the lawyer's aid. Sometimes it's true a question is asked of counsel with the idea of persuading a colleague in mind, and at such times the lawyer will sense that she is being talked through and not to. But other times, the judge may be trying to cue counsel that an argument pursued with gusto is a certain loser, so counsel should shift gears and go on to another argument. If counsel is too wedded to a script or an outline, that kind of cue may be missed. I appreciate that there's a real difference in the dynamics of a 9-member bench, and we always sit all 9 of us, and the typical appellate panel of 3 judges. One can have a conversation accommodating clarifications, interjections, and interruptions among 4, counsel, and 3 judges, much more readily than among 10. Our appellate courts in the United States, unlike the typical appellate court in civil law countries, we do not assign any one judge to be the reporting judge to take the laboring oar in a case. Each of us prepares fully and individually, and our chief does not decide which one of us may speak. We jump in whenever we please within the allotted time. And a justice sitting on one end, as I do, of our long and barely curved bench, sometimes doesn't see that questioning is continuing on the other side. So occasionally we step on each other's questions, we interrupt each other, but when we do, it isn't intentional. It's because we don't realize that the colleague is continuing a line of inquiry. And I certainly prove that from time to time, that we can't always see what is happening on the other side. Although our format surely has flaws, and some would prefer more time or fewer questions, I think that argument largely succeeds in what it's supposed to do. That is, it more than occasionally reduces or diminishes confusion and conflict, and it gives counsel an opportunity to face the decision makers a last clear chance to convince the justices concerning points on which the decision may turn. In typical civil law courts abroad, in contrast, appellate advocates ordinarily speak with barely any interruption. They make grand pleadings, and when they complete their presentations, the presiding or reporting judge may ask a question or two, rarely more than a few. I would find it very hard as a judge to listen without falling asleep to a lawyer talk for hours on end, to sit there passively. We don't allow cameras in our court. For the December 2000 Bush v. Gore argument, we made an exception. No cameras, but we provided an audio tape of the argument instantly as soon as it was completed. We supplied it to the media, and the tape was played on radio stations and TV stations. Our photographs were matched with our voice when we spoke. There was no case last term that prompted such an exception. Let me turn finally to how we reach our decisions. In a typical 2-week sitting period, we will meet on Wednesday afternoon to discuss and reach tentative decisions on the Monday cases. And then on Friday, we will discuss cases that came up on Tuesday and Wednesday, plus all of the accumulated petitions for review for that period. On the second Friday afternoon, the chief will circulate our homework assignments for the sitting just completed. That is, he will determine who is the writing judge whenever he's in the majority, and when he's not, the most senior judge in the majority will assign the opinion. So I don't ever get to choose what cases, the cases in which I will write for the court. At all of our conferences, the chief speaks and votes first, and the junior justice speaks and votes last. Our current chief, who's written a very good book about the way the Supreme Court works, expressed the disappointment that he felt when he was a new judge on the court, when his significant contributions, he said, were not heeded because votes had already been cast higher up the line and there was a clear majority for one position or another. But he reported with newfound clarity that having risen first from number 9 to number 7 to number 1, that his idea of more of a roundtable discussion was academic, fine in the abstract, but unlikely to contribute much in practice, and at any rate, doomed by the seniority system to which the senior justices naturally adhere. Yes, sometimes I detect a certain impatience and expectation of brevity when the vote comes round to me, the 8th justice, to speak, and there are already 6 votes and more for one position. But the last place, the one now occupied by Justice Breyer, can have a heady moment or 2 or 3. When the 9th vote ends a tie. And that happened last term, for those who look at our opinions very closely, in 2 cases where Justice Breyer was the 5th vote for a particular position. One was a case involving searching passengers on a bus, and the other was about drug testing in public high schools. The justices who speak last do have one advantage, that is, we can take into account what the justices who spoke first said and try to respond to those arguments. Well, our discussions are often spirited, but seldom protracted. It will come out in the writing, the chief is likely to say, after we have talked, in his view, long enough. And so it does. At least once each of the 9 terms I've served on the court, an opinion writer finds that the conference position won't write in whole or in part, so the writer ends up taking a different view. And similarly, once or twice each term, an opinion circulated as a dissent attracts the majority's approval and becomes the opinion of the court. I've seen that happen. These 2 occasions are vivid in my mind when a position that started out with only 2 justices ended up with 7, speaking for 7. So we do pay attention to what each other writes. And turning specifically to the circulation of written opinions, my colleagues take very seriously the label opinion of the court. They show that concern in what I call Dear Ruth letters, because internally we use only first names. And a Dear Ruth letter will commonly say, please consider adding, dropping, deleting, revising to make this or that point. Or more hopefully, I will join your opinion if you will take out, put in, alter, or adjust as follows. I am comforted at such times by a remark once made by Chief Justice Hughes. Hughes said that during his many years on the court, he always tried to write his opinions logically and clearly, but if another justice whose vote was necessary to make a majority insisted that particular language be put in, then in it went, and let the law reviews figure out what it meant. In truth, much more often than not, my colleagues' comments help me to improve an opinion. There is nothing better than a good dissent to force one to sharpen our presentation for the court. I prefer and continue to aim for opinions that get it right and keep it tight without undue digressions or decorations or distracting denunciations of colleagues who hold different views. But I doubt that I will ever match Justice Breyer's tremendous restraint in religiously refusing to use footnotes in his opinions. Yes, in something between 24 and 30% of the argued cases, we have divided 5 to 4 in recent terms. But as I said, our unanimity rate is higher than that, close to 40%. But the most impressive thing about the court, in my view, is that despite our sharp differences on some vital issues, the court's December 12, 2000 disagreement on the recount of votes in Florida is a prime example. We remain good friends, people who respect each other and genuinely enjoy each other's company. That mutual respect is only momentarily touched in most instances by our sometimes strong disagreement on what the law is. We know that the institution we serve is ever so much more important than the particular individuals who compose the bench at a given time. Our job, the job of judging in a U.S. court generally, is in my view the best work a U.S. lawyer could wish for. We serve no client. Our commission is to do what is right, what the law requires, and what is just. And the guarantees of judicial independence that the Founding Fathers wisely placed in the Constitution, life tenure, and no reduction of our salary while we hold office, help us to do just that. In many constitutional courts abroad, long, non-renewable terms are used to serve that same function of preserving judicial independence. So 9 or 12-year terms that can't be renewed are common in European countries as a means to secure judicial independence. I sometimes contrast the security of my job with the relative insecurity of court judges who must stand for periodic elections. And in 42 of our 50 states, the American Bar Association reported at least some judges face elections. One can certainly understand the origin of judicial elections in the days when the King's justices were so distrusted, colonial days, but at least in my judgment, nowadays, elections are a dangerous way to choose or retain judges. Well, that completes my nutshell account of the Supreme Court's operations. I hope what I've said has sparked some questions, and so I'd now like you to present them. Thank you.
Well, I said that. I also said, in fact, I said, who's the expert who said that's fine?